Greetings and welcome to Novation, Substituted Contract from American Jurisprudence. Let's get started from where we left off, but before we do that, just remind everyone to please hit the like, and welcome to Liberty Absurdity. Greetings. And before we get started here, I just want to remind everyone this is strictly for the educational entertainment purposes of this YouTube broadcast, not to be used misconstrued for anything public, private, personal, financial, lawful, legal, tax, or otherwise. So please don't do this at home. All right, that being said, let's get to it. So before we get started, just a little refresher here from where we left off here on the definitions here. This just give a refresher where we went over last time in depth. But a novation is defined as a mutual agreement among parties, all parties concerned, for the discharge of a valid existing obligation by the substitution of a new valid obligation on the part of the debtor or another, or a like agreement for the discharge of a debtor to its creditor by the substitution of a new creditor. So some of these terms here, just to get clear here of what we have here. Discharge is to relieve someone from a debt or obligation. Valid meaning having some value. There has to be value in consideration in any contract. There's an existing obligation and is substituted by a new, not just an obligation, but a new valid obligation, because there has to be valid and valid to replace value, on the part of the debtor or another, or a like agreement for the discharge of a debtor to its creditor by the substitution of a new creditor. So there has to be basically a new contract, and the previous contract is discharged, the debt is discharged, or the obligation is discharged by its creditor by the substitution of the new one. So the term is also defined more broadly as a mutual agreement between the parties concerned for the discharge of a valid existing obligation by the substitution of a new valid obligation, or simply as a substitution of a new contractual obligation for an old one. Now, according to the restatement, a substituted contract is defined as a contract that is itself accepted by the obligee in satisfaction of the obligor's existing duty. Thus, a novation has sometimes been defined or described as a form of substituted contract, hence the name. So from there, let's get started where we left off, which was section 13. And just before this, we left off section 12, was the intent to accomplish novation. So once we have this caution, the intent means there must be a meeting of the minds if a novation is to be valid and binding. Thus, unilateral action by one party is typically insufficient to effect a novation. Big point here, footnote 8, and that is Barnett Bank of Marion County versus Shirley, and that was a Florida District Court of Appeals, 5th District, 1995. Unilateral decision by lender to change formula for advances under loan agreement was not a novation. That's an interesting case there. Okay. Let's get back to where we left off on section 13. Again, this is from the 2011 edition of American Jurisprudence. So it is quite a few years old, over a decade. However, a lot of the foundational principles apply. The only things that might change over time are the cases that are supplemented. And you'll see the supplements here from the previous ones too that are added in for this 2011 edition as it goes. But that's why I say that this is not to be used or construed for any kind of legal lawful advice. You'd have to do your own research, but this is a great starting point because you can see if any of these cases here have ever been overturned to know if they're still binding or not. Okay, let's continue here. By original and new obligors, okay, in analyzing an alleged novation, a court must consider whether the evidence clearly shows consent. Excuse me. There has to be evidence that clearly shows consent by all parties. Now, this is a good point here, and this is footnote 1. And that's Shank versus William R. Hague, Incorporated. And, 1999. That's in analyzing an alleged novation. court must consider, this is important here, must consider whether the evidence clearly shows consent by all the parties. Great ones here. Acceptance of the terms of a novation may be implied from the facts and conduct of the parties in relation thereto. And that's from footnote 2, and that's the same case here and some other ones here as well. In general, it is not necessary that the assent of the parties to a contract, including one of novation, be given at the same instant. And the instant means that that's one particular case, motion, hearing at hand, not the instance of a situation. Very confusing term sometimes, but the same instant. Comment. Although assent of the obligor of the new duty is always necessary, a novation is possible without the assent of the obligor of the original duty if that party has an intended beneficiary and does not disclaim. Where novation is affected by the substitution of a new creditor, it is essential that the debtor assent to the proposed substitution and agree with the new creditor to perform and discharge the new obligation. Otherwise, the new creditor will have no action against the other debtor. Let's see, that's footnote 6. Detroit Postage Stamp Service, 1914. Oh boy. So some well-established authorities here to refer to. Let's continue. And this is section 14 by sureties. A surety's intent to substitute a new agreement for a prior guarantee and to release one of the prior guarantors may be inferred from the circumstances. Okay. Well, the first thing we need to do is define some of these terms we just came across here, because I'm not sure about this audience, but that sentence didn't make a whole lot of sense until we really dig in here. I can kind of speculate what it might mean, but I can guarantee you that there is terminology here that means more than the word may seem. So let's start with surety. And of course, as always, we'll have to jump over here to Black's Law Dictionary. And zoom in a little bit here. In 9th edition. And we need to get to surety. So let's see, that's up in the S's. Let's see if we can get up there a little quicker. Okay, here we go. Surety. 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 14th century. A person who is primarily liable for paying another's debt or performing another's obligation. Debt, obligation. So this is a person. The surety is the person. Although a surety is similar to an insurer, one important difference is that a surety often receives no compensation for assuming liability. A surety differs from a guarantor, who is liable for the creditor only if the debtor does not meet the duties owed to the creditor. The surety is directly liable. Wow. So, okay, well, instead of me having to read that again, we have a clarification here. The words surety and guarantor are often used indiscriminately as synonymous terms, but while a surety and a guarantor have this in common, they are both bound for another person. Yet there are points of difference between them which should be carefully noted. A surety is usually bound with his principal by the same instrument, executed at the same time, and on the same consideration. He is an original promisor and debtor from the beginning, and is held ordinarily to know every default of this principle. Usually, the surety will not be discharged, either by the mere indulgence of the creditor to the principal, or by want of notice of the default to the principal, no matter how much he may be injured thereby. On the other hand, the contract of the guarantor is his own separate undertaking, in which the principal does not join. It is usually entered into before or after that of the principal, and is often founded on a separate consideration from that supporting contract of the principal. So there it is. A surety, on the broader sense, is one who is liable for the debt or the obligation of another, whether primarily or secondarily, conditionally or unconditionally. In other words, The term surety includes anyone who is bound on an obligation which, as between himself and another person who is bound to the, here, let's zoom in a little more here, it's getting hard to read. Boy, that fine print. There we go. Okay, in other words, the term surety includes anyone who is bound on an obligation which, as between himself and another person who is bound to the obligee for the same performance, the latter obligor should discharge. Term surety, anyone who is bound on obligation between himself and another person who is bound to the obligee for the same performance, the latter person bound should discharge. In this sense, surety includes all accessorial obligations by such terminology. Guarantors and endorsers are kinds of sureties. A surety in the narrow sense is one who is liable in form primarily on the debt or obligation of another. His obligation is accessorial in that of the principal debtor, but it is direct and not conditioned on the principal debtor's default. In this sense, suretyship differs from guarantee and endorsement, which are conditional, secondary obligations. The word surety is in the majority of American decisions used in the narrower sense to indicate a primary obligation to pay another's debt, to distinguish it from the secondary obligation of a guarantor. This terminology has the advantage of indicating, by the use of the one word surety, an obligation which is at once one to pay another's debt, but which at the same time is not conditioned upon another's default. Wow. So there's a difference between the guarantee and the surety. Essentially is the condition of the guarantee or endorser, whereas surety is an unconditional. We say it's a unconditional liability for paying another's debt or performing another's obligation. Surety receives no compensation for assuming liability, and I think this cuts to the fact of there being no conditions. Liable for, only if the debtor does not meet the duty. See, the guarantor has conditions. Is liable only if the debtor does not meet the duties owed to the creditor. The surety is directly liable. So, let's get back to it after that deep dive into surety. All right. So, by sureties. A surety's intent to substitute a new agreement for a prior guarantee. Okay, so now we see here. A surety's intent to substitute a new agreement for a prior guarantee and to release one of the prior guarantors may be inferred from the circumstances. A novation without the consent of the surety or guarantor discharges such surety or guarantor. In fact, so to discharge or relieve them of their obligation or debt. So it needs consent. In fact, some jurisdictions have statutory language to the effect that any change in the nature or terms of a contract is called a novation, which releases a surety who has not consented to it. Nonetheless, a guarantor's subsequent ratification of a note, which it contended was an unauthorized novation, which released it is sufficient to establish its consent. Subsequent ratification of a note. Okay. And in a proper case, the guarantor may be precluded from claiming the absence of consent to a novation. Oh, in a proper case. Interesting there. Footnote 5, there's your proper case, 1976. Southern District of Georgia. Caution. A reorganization plan discharging a Chapter 11 mortgagor, debtor in bankruptcy does not act as a novation of the mortgage debt, so that one who is a surety of the debt remains liable. The mortgagee's failure to object to the plan does not constitute consent to a novation of the mortgage, and the reorganization plan affects only the creditors and the debtor, not a surety of the debtor. Ah. Interesting there with a Chapter 11, and that would be from a person, an organization, business, something of that sort, for the mortgage debtor in a bankruptcy does not act, that's the reorganization plan, does not act as a novation. So the surety remains in effect, it seems. Yes. Okay. Good case citations there. It seems like the chat's jammed, or maybe that's just on my end. Let's double check here. Yeah, make sure we're all online here and not just speaking to the ether. All right. Okay, I guess we're all here. So the first one was by the surety, novation by surety, now by obligee, section 15. The assent of the obligee as one of the parties to the original obligation is an essential element of a novation. Although it has been said that the obligee's consent must be established so as to leave no room for doubt, such assent need not be given expressly, but may be inferred from the circumstances surrounding the transaction. As we saw before, the consent can be inferred, or assent in this case, so this is a one party, may be inferred from the circumstances surrounding the transaction and from subsequent conduct, such as acquiescence to the novation agreement by acknowledging receipt of the agreement, negotiating a check from the third persons for purchase of the franchise, and accepting third parties' performance under the new agreement. Acknowledging receipt of the agreement. There's a good one right there. Acquiescence. But that's just one circumstance. You'd have to do more. Seems like a catch-all for that. The substitute contract defense may be raised by a co-obligor to the original contract if the obligee accepts a subsequent agreement signed only by the other obligor as a substitute for the original contract. The act of the United States Attorney for the Northern District of Illinois' attorney in interrogating a drug defendant pursuant to an agreement between the defendant and other United States attorneys wherein the attorneys were pledged to make every effort to have the attorney file a motion for correction of sentence did not constitute a novation of contract requiring the attorney to file a motion. There is no indication of an action evidencing an intent by the attorney to be substituted in the agreement. Oh, geez. Now we're on to section 16, consideration. Like all contracts, the contracts of novation must be based on good and sufficient consideration. Consideration is sometimes stated as a separate element or requirement by the courts. However, the consideration need not be pecuniary or even beneficial to the promisor. What's pecuniary? Well, it's money related, right? Financial. So, however, the consideration need not have a dollar amount to it, right? Pecuniary or even beneficial to the promisor. A loss or even an inconvenience to the promisee, the relinquishment of a right, such as the discharge of a debt, or the postponement of a remedy, such as the discontinuance of a suit, or a forbearance to sue, will be sufficient. Thus, required consideration is present when the original contract is partially executory on both sides, since both parties suffer a legal detriment through the mutual cancellation of executory contractual rights. Mere mutual agreement of the parties may furnish the necessary consideration. Mere mutual agreement. So there we go. Comment. Consideration to support the discharge of the original duty can usually be found in the promise to undertake a new duty. However, neither a promise to do that which the promisor is already bound to do, nor performance of an existing legal obligation constitutes a valid consideration for a novation, where an agreement merely reduces the amount owing to that which has already been paid. It is not supported by a new consideration, and so is not a valid novation. All right, so we had consideration. Now we're on to conditional agreements, partial novation. So see these conditional agreements. Generally assume that one does not surrender an existing obligation for a promise to perform in the future. Where an alleged novation agreement is such that only performance of the new promise discharges the obligor's obligation, the agreement is at best an executory accord. Since in a novation the existing obligation is extinguished by the acceptance of a new promise in satisfaction of the original obligation, value for value. Hence, if the novation contract is conditional, the novation can only take effect upon the accomplishment of the condition. So it can't be to perform in the future. It must be take effect upon the accomplishment. Therefore, if it takes place in the future, that's a condition that may or may not happen. The parties may agree to a partial novation. However, the essential element of such novation remains the extinguishing of the original contract by the substitution of a new one. So it can't wait for some promise to perform in the future. And that's footnote 1, American Bank and Trust. Interesting there, 1982. And we're on to section 18, assumption or delegation of obligation generally. A novation may occur by a three-party agreement whereby the delegatee assumes the duty of the original obligor, and this assumption is accepted by the obligee in substitution for the original obligor's liability. Where the obligor's duty has been assumed by another, the release of the original debtor from all liability for the indebtedness is an essential requisite to a novation. Wow, that's footnote 2. Imperial Hotels versus Door, 2001, applying Michigan law. Interesting there. Then we have another one here from Illinois, 5th District, 1984. No, that's a different one. Illinois appellate. Okay. In accordance with this general principle, the mere assumption of a debt by a third party is generally not sufficient to establish a novation of the original contract, unless there is also shown an intention to release the first obligor and to extinguish his liability. Otherwise, the assumption of the debt by the third party will be presumed to be merely additional security. The same rule applies to a delegation of the obligation of performance by a general contractor. Interesting there. Additional security, the assumption of debt by a third party. Interesting there. Comment, a novation results when a third party promises an obligor to assume immediately and in substitution for the obligor's duty, a duty to the obligee to render the performance that was due from the obligor, or some other performance, and the obligee agrees with the obligor or with the third person to that substitution. However, a mere promise by a third party to assume the obligor's duty, not offered in substitution for the duty, does not result in a novation. And the new duty that the third party may owe to the obligee as an intended beneficiary is in addition to and not in substitution for the obligor's original duties. Ooh boy. So that comment there was pretty lengthy. So let's break it down a little bit here. The novation results when a third person promises an obligor to assume immediately and in substitution for the obligor's duty. So when a third person promises to assume immediately that obligation or duty or debt, a duty to the obligee to render the performance that was due from the obligor or for some other performance, and the obligee agrees with the obligor or with the third person to that substitution. However, a mere promise by the third party to assume someone's promising to do it does not result in a novation. Okay, really splitting hairs here. An obligor is discharged by the substitution of a new obligor only if the contract so provides, or if the obligee makes a binding manifestation of assent forming a novation. Otherwise, the obligee retains his original right against the obligor, even though the obligor manifests an intention to substitute another obligor in his place, and the other purports to assume the duty. Wow, so that's a restatement of the second restatement of contracts, huh? And 2009 case here, the Reserves Development versus Crystal Properties. Settlement agreement between members of construction consortium regarding claims against owner of constructed facility, which agreement assigned now bankrupt consortium member as leader, did not act as a novation of the original consortium agreement, which contained an arbitration clause and an ipso facto provision that prevented any insolvent consortium member from having any decision-making authority under the agreement. And thus, ipso facto provision was not nullified, so as to give bankrupt member the authority to enforce arbitration provision regarding facility owner's claims. The settlement agreement only applied to close out issues related to the constructed facility, and it was not intended to nullify the original consortium agreement, but rather modify it with respect to close out issues. So there you go. That's the modification. It's not a novation. All right, we're on to knowledge and consent. Section 19. Consent to an assignment is not enough to cause a novation. The fact that the creditor has knowledge of the assumption of its debtor's obligation by a third person does not necessarily establish the creditor's assent to a novation. Accordingly, mere knowledge of and consent by the creditor to the assumption in whole or in part by another of its debtor's obligation will not, standing alone, create a novation so as to release the original debtor. Rather, the creditor's expressed assent to give up the original debt is required. This rule may also apply to a delegation of the obligation of performance by a contractor. So this is footnote 4. Berg versus Liberty Federal Savings and Loan Association in Delaware 81. And we also have here from the footnote 1, while the other party to the contract may agree to accept the responsibility of the assignee in place of the assignor, thereby making a new contract by way of novation, the novation must be such as to release the original obligor and substitute a new obligor in his place. All right. And we're on to section 20 here. Second here. Just checking up the chat. Looks like it's just starting to refresh here. Give me a moment here. Let me check back over here to the chat. Hope everyone is having a great night. One second here. All right, there we go. Greetings. Ipso facto is a fun Latin phrase indeed. Yeah, this is strange how I will learn something here and soon after encounter the concept in the wild. I find that we're constantly exposed to these concepts, and once you are aware of them, then you see it everywhere. That's what I've found. And of course, less TV is Oakland love. Yeah. Sup. Glad you all made it out, and let's continue here with our novation. This is some pretty important stuff here because actually these kinds of changes happen all the time, and to know the difference between a modification and a novation in your contracts make a big difference if you just consent to things going on. And we're seeing here how it can go both ways. It could be strictly through acknowledgement of it, that it could be evidence of it, of circumstances where it could be valid. So these are things to be aware of, is that anytime you see a change in any kind of obligation owed or someone that's paying you as an obligation, any kind of change in that or shifting to third parties, to be aware Lots of interlopers that try to involve themselves in other transactions to their advantage and disadvantage of the other parties. So yeah, let the people need to be aware. Oakland PD outside the bus as we speak. Interesting. Ask them if they're public servants and see what they say. Okay. Partial payment of the debt by a third person who has assumed the obligation, alone or in combination with the creditor's knowledge of the third person's assumption of the debtor's obligation, does not constitute a novation as a matter of law or necessarily establish assent on the part of the creditor. When a third party contracts with a debtor to assume its obligation and perform in its stead, the mere acquiescence in such an assumption by the creditor is not an assent to a novation, nor is it a mere acceptance of a part payment made by the third party. Performance of the contract by the substitute is not necessarily inconsistent with the continued liability of the original party, even though performance of the obligation by the third party may discharge the duty of the original obligor. A novation may be inferred, however, by the obligee's acceptance of part performance from the new obligors if the performance is made with a clear understanding that a complete novation is proposed. Footnote 4, Newport Plaza Associates, applying Rhode Island law. Okay, nothing good there. Oops, where we go here? That was footnote 4. A novation occurs where a contracting party accepts performance by an assignee with knowledge that the assignor does not intend to be liable under the original contract, as where the creditor deals exclusively with or pursues only the assignee for payment. Okay. Performance by an assignee with knowledge that the assignor does not intend to be liable under the original contract. That's the novation, as where the creditor deals exclusively with or pursues only the assignee for payment. Thus, assent to the substitution of a new debtor who assumed the debtor's obligation may be indicated by the creditor by bringing an action solely against the new obligor. However, bringing an action on a note against the primary debtor and reducing the note to judgment does not constitute a novation. That releases the guarantors of liability. Remember, the guarantors conditional. And let's see, that's footnote 8. Champaign National Bank versus Babcock, Illinois, 1995. According to the restatement, the legal effect of a repudiation by an assignor of its duty to the obligor of the assigned right is not limited by the fact that the assignee is a competent person and has promised to perform the duty. If the obligor, with knowledge of such a repudiation, accepts any performance from the assignee without reserving any rights against the assignor, a novation arises, by which the duty of the assignor is discharged, and a similar duty of the assignee is substituted. Okay, and that's footnote 9, restatement, second of contract. So we're going to have to go over this sometime, the restatement of contracts. I have that edition, so that might be a good one for the future. On the other hand, consent to a novation may not be implied where an insurance policyholder, faced with the accomplished fact of the assignment of the policy by the insurance company, continues payment of insurance premiums to the assignee so as not to abandon its investment. Interesting there. That's geez, premium payments. Sansucci versus Division of Florida Land, Continental Sansucci. Yeah, that's on Aventura in Miami, 1984. Yep. The city of the future, they called it. That didn't live up to its name. Okay. Let's proceed. Okay, we're on to section 21, generally. This might be a good place to leave off for the next one because we're hitting around that mark again, where the eyes can get glossed over going over all these terms. But we're going to be going over taking new evidence of a debt does not presumptively extinguish the debt and affect a novation. So this is going to be an interesting one to go over, but I think we have a lot to unpack from what we just went over, which was quite voluminous. And Les TV is still here. Thank goodness you didn't get surrounded here. Let's see what I missed out. Told him UC is all I have to say. Yeah, don't do that. Hope all went well for you. Looks like it did. We'll have to kick the door in on the bus. Indeed, that would be quite funny. Well, with that said, I would like to thank everyone for coming out. If there's any other kind of questions we have about the novations, let me know right now, and we can go ahead and look back to what we just went over. Otherwise, we'll be continuing with a part 3. It looks like on this we have we should be able to finish it in one more session. But to see these distinctions, yep, only armed with legal knowledge and knowledge of the law here too, because a lot of this is based into contract law, which is really what guides most of what we see in the legal system anyways. But this gets down to the essence of it, liability, obligations, value, considerations. All of these come into play when we're dealing with contracts, and as things change, as everything does in life, we have to have ways of dealing with it equitably between the parties. And novation is one way to ensure that everyone is getting their fair say in the way the contracts are executed so as to not stray from their original intent. Well, with that said, I would like to thank everyone for coming in. I hope to see you all on the next one, and we'll continue learning more from American jurisprudence. Peace out.